Honorable judges of the Supreme Court, my name is Waikwa Wanyoike. I'll be presenting primarily on two issues. I'll present on the issue of universal suffrage, and I'll also present on the new Election Laws Amendment Act, but specifically, what does it mean to have what Parliament would want to tell us is a new Section 83 and the impact to the determination the court will make. Just quickly before I proceed, I just wanted to point to the court in regard to a question posed by Justice Ojwang on evidence, that for purposes of the record, may it reflect that that question that was posed in terms of admissibility of the evidence from Dr. Roslyn Akombe, we are relying on Section 33B of the Evidence Act, and we are saying that whatever information my lead counsel was referring to was information made in the ordinary course of business. But I'll leave it to the court to look at that. The second thing, just before I get to my arguments, just for purposes of the evidence on violence, we would also invite the court to look very, very closely to a volume filed by the second respondent relating to affidavits prepared by returning officers from all those constituencies where election never took place. May I then move to my submission? I'm hoping I'll be within time. I'll do my best. And again, sorry, I should say this because this is important for the court. In terms of, and again, because we don't have much time, in terms of the authorities we are relying on, we have filed a case digest. That case digest contains over 100 authorities, a list of over 5,000 pages of authorities. We realize how overwhelming that is. We've also filed an electronic copy of those authorities, and we've highlighted in the electronic copy the sections we want to rely on. So where I may not be able to go to the authorities, then I would refer the court to those. May I start?
Just before you start, I'm just interested in, I don't know whether this is a new style of citing authorities, where you file a case digest, 100 authorities, you throw it to the judges, say plow through that, you will find your way. Because the best way to go, the way I know and you know, is that when you're making a submission, you support it with an authority. And it is for you to point at the case digest, say go this page, at this paragraph. But for you to file a case digest and say plow through that and you'll find your way, it might not be very helpful.
My Lord, I hear you. I also hope that the court appreciates that we're working also under very strict timelines. So to the extent that I can, and to the extent my colleague will, we will do that. But we've also tried to be as of much assistance as we can be to the court. In fact, I should point this out. The digest itself not only puts the page numbers where the authority is, it points the page in the authority where you will find the specific references. Yes, Honorable Chief Justice.
That is why, Mr. Waiwa, I told your friend, I think it was Mr. Uma. Is it Mr. Uma or Mr. Musyoki? That when you are making a proposition in respect of which you have an authority, cite that authority at that point. So that when we look at the answered report, we are able to go to the report you're citing and see how it supports your argument.
I'll do my best.
Don't argue until the end and then you tell us, I rely on these authorities. On what point?
I'll do my best. And in fact, just for the benefit of the court, we actually have categorized in the digest the authorities based on the themes. If I may proceed, I'm getting a bit worried about my time. The starting point in the universal suffrage issue is to ask the question, who is a president? And who is a president in the context of Kenya's constitution? And to answer that question, we go to Article 131E. What does Article 131E say? It says that a president is a symbol of national unity. And in assessing the validity of this election, then you must assess whether, in fact, the aspiration given to the office of the president under Article 131(1)(e) has been met. But what does the president do? That is my second question. The president, under Article 131(2), promotes and enhances unity of the nation. So then the question for the court is, which nation in the context of October 26th election? And did the election take place in the nation? Then the third question, where does the election of the president take place? And if you go to Article 136(1), then you find that the election of a president takes place as a form of a national election. These are important principles. And I would refer the court even to the preamble and the kind of nation that the preamble recognizes. So what is a national election? And that is Article 138(2). And 138(2) says, a national election for the president has to take place in all the constituencies. 290. Now we have 291 because of the diaspora. So is it a presidential election under Article 138(2) if it's not taken place in all the 290 constituencies? I think that's a question the court will have to determine. Then I move on to ask, how does it happen? How does an election of the president happen? What does the Constitution say about that? And we start with Article 138(3)(a). In terms of the extent of entitling every registered voter to vote. Entitlement. So anybody who wants to vote should be given an opportunity to vote. Then the question becomes, did everybody who wanted to vote on October 26th vote? Is that a violation of 138(3)(a)? And I would also want to refer the court to Article 81D. What does Article 81D say? Because now, once we get to 138, now we start talking about the universality or the universal suffrage concept. 138D says, the electoral system shall comply with the following principles, and D, universal suffrage based on the aspiration for fair representation and equality of the vote. And may I pause here and say, the Constitution doesn't anticipate or expect our election to be about a winner or a loser. The Constitution expects that people vote as a means of expression. If it was about losing and winning, some of the candidates who have been participating would not get a single vote. So that becomes a critical consideration. And in terms of Article 38.2, 38.2 also bolsters the concept of universal suffrage. When you look at the quality of election that is expected under the Constitution, you go to Article 81E. And what does Article 81E say? It says it has to be a free and fair election, and then outlines the elements of what a free and fair election is, including free from violence, intimidation, improper influence, and my colleague has already handled that. We may want to ask, what is universal suffrage? We are talking about universal suffrage. What is the definition of universal suffrage? Universal suffrage just simply means the opportunity for almost every adult citizen to vote in a political election. That's what it means. So, in my submission, I submit that beyond the Constitution, this court has to look at the international instruments that we are party to. And I would refer the court to our written submission, but emphasize among those is the Universal Declaration of Human Rights at Article 21 and the ICCPR at Article 25, in terms of contextualizing this concept of universal suffrage. I don't want to dwell a lot on what is a free and fair election, because I think in terms of answering the question of universal suffrage, you will have to ask yourself, did every adult who wanted to vote, vote? You will ask, was what was organized on 26th a free and fair election? And was it an election that allowed for the free expression of the will of the electorate? When my lead counsel submitted, she dwelt a lot on the issue of violence and intimidation. But is that the only issue that vitiates the election of the 26th? It's not. In fact, one of the primary issues is turnout. Turnout. Just the number of people who came out to vote. What was the turnout? And when you retire, this is in volume 2 of our documents. IBC's number, 38.8%. Let's make it 39%. What was the turnout in August 8th election? 79.5%. So we make it 80. Why was this turnout affected? The simple answer you might get is because of violence and intimidation. But that doesn't tell the whole story. The whole story is that there was lack of trust on IBC. Why? Because in areas even where there was no violence or there's no evidence of violence, the turnout was still very low. Let me just illustrate. Makueni, what was the turnout? 4.6%. Do we know of evidence of violence relating to Makueni? What was the turnout in August 8th election? 78.8%. Nyeri turnout, 84.2%, but it was higher by 2 percentage points in August. Meru, 63%. In August, it was 78%. Wajir, 19.4%. It was 73%. I can do this with every of these counties. So the question then is, in these places where there is no evidence of violence, what do we attribute that to? And in my humble submission is that there were other factors as submitted by Ms. Soweto that affected turnout and vitiates the election. Why is this important? Because it speaks to whether the turnout confirms the president being a symbol of national unity, whether the turnout confirms that there was universal suffrage. And if I just may make one anecdotal point on this, even if you were to eliminate the 1.7 million in places that were seriously affected by violence, what do you end up with? You only end up with about 42.2%. And what was, you contrast that with the 80% in August. So we also submit that the denial of or the cancellation by the IEBC in 25 constituencies also affects the question of suffrage. And the first issue is that when you go to Section 55B of the Elections Act, you don't find anything speaking to cancellation. So cancellation in itself was illegal. And again, tying to the point that you don't just vote so that your candidate wins. You vote sometimes to express yourself. And so, even assuming cancellation can be found to be supported somehow by law or directives, is it a reasonable limitation? And we submit it's not, because the worst that it does is to lower the dignity under Article 28 of those who are not given the opportunity to vote. You're just simply saying your votes are less deserving. Yes, you pay to the pot of 12 billion to organize this election, but no election for you. Let me then sum that up and say, in our submission, when you look at the entirety of the context, not only was violence important in terms of showing that this election is vitiated, but in terms of the number of people who are able to vote and the reasons why they couldn't vote affects the election. I noticed that I may be running out of time, so I want to go to Section 83 of the Elections Act. And may I start by...
Before we go to the next, that's a different subject.
Yes.
I still don't think you, I asked a question earlier, and I was hoping that you would address it, about the rights of those who voted and the rights of those who didn't vote. And you may want to address this on the right not to vote, because the right to vote also comes with the right not to vote. You can exercise that right as well. So if you can categorize for us, there's universal suffrage, everybody registered to vote, there are those voters that were able to vote where there was no violence. There are also those voters who chose not to vote where there was no violence. Then where there was violence, they were not able to vote. So there are different categories, and also one can exercise not to vote. So how, on a point of balance, would you then suggest that you don't hold an election where people can choose to exercise not to vote?
I think I would want to answer that. I'll try to explain that in two ways. The first is the right not to vote. And my submission is we have to look at the circumstantial evidence and ask ourselves, is it that all of a sudden about 50% of Kenyans who normally vote, and by the way, the comparison should not just be between August 8, 2017 and October 26th. If you go historically, what the turnout has been. So is it just because they didn't want to vote? Or is it because they did not want to vote because there were other factors, as explained, including the independence of the commission that affected their decision not to vote? And my submission would be, when you look at that circumstantial evidence, then it is clear that these factors that we are submitting to court affected the turnout and affected the decision by those people who didn't want to come out and vote. The second point on this is when you look at the information that was going out in relation to intimidation of voters, in relation to the fact that a candidate had withdrawn, how does that also affect the ability of people to make that decision not to come out and vote? And so in our submission, it's cumulative. But circumstantial evidence shows that it wasn't based on the fact that people just decided this time, you know, everything is right, I will not come out and vote. I want to go to section 83. And just to sort of give context to that, and we have this in the affidavit of John Jomue, we have provided information on how a new Elections Law Amendment Act came to be. In fact, there is an affidavit of the leader of Jubilee Majority, which also explains that. But our submission is that that amendment, the law itself, was ill-conceived, first to defeat what this court had decided after August 8th, but more importantly, calculated to affect how the court should determine, or the standard the court should use to determine this October 26th election. And in our submission then, we are saying that because Section 83 becomes central, and we've seen the submissions of the Attorney General, we've seen the submission of the third respondent, they are saying Section 83, as currently amended, is the applicable law. Then the question is it? And we submit that it's not, first because of the issue of retrospectivity. The event that has led us here happened before the law took effect. When did the law take effect? November 2nd. When was it assented? October 28th. When was the election held? October 26th. So it should not be used as a basis of assessing.
My Lord, with profound respect, I think we have to remain truthful. We have to try and be candid with the court. To the best of my knowledge, that law did not become law because of presidential assent. On the contrary, it is by operation of law. So it wouldn't be good to come here and make a bold statement that it received a presidential assent in order to become law. Number two, my Lord, before my learned friend resumes, it's quite clear that the law became law after the elections, and it cannot have retrospective effect. So we shouldn't waste time on matters that will not help the court to deal with the issue before it.
Unless all the parties are conceding on this point, then that the standard applicable is the standard that was enumerated by the Supreme Court in its August 8th, or the decision from August 8th, then I wouldn't push it. But as I said, I've seen it being argued in the third respondent's memoranda.
Mr. Waikwa, just continue. You are giving us your grounds. You said first?
Yes, retrospectivity.
The next?
Yes, and I hope Counsel doesn't interrupt me again. You know, some of us are still trying to overcome nervousness when we make presentation in this forum. But before I go to that, it's important that I should have wrapped up my universal suffrage argument that really at the end of the day, the legal duty to ensure universal suffrage is on IEBC. That is the mandate of IEBC. So the first argument is that it doesn't apply because of retroactivity. And I just want to go to the authorities. I would refer the court from page 63 of our case digest, where we discuss issues to do with Section 83. The second is that even if it applies, it does not really matter. Because when you go to your decision in Raila Odinga, specifically paragraph 194 and 212, what you are doing is not just to look at the constitutionality of Section 83 as it was. It's to explain what the Constitution requires a Section 83 to look like. Because Section 83, as the court has said, would be a normative derivative. So it must meet the constitutional master. And so even taking into account that now they've changed all to and, it doesn't matter. The court, when it reads it, it has to read that and as being a disjunctive test. And I will refer you to the authority of Morgan versus Simpson because that concept has been discussed there. But in any event, we submit that this court can just look at that section, and this ties to my other point, in terms of application. In applying that section, what meaning do you give it? Because the court can either look at a provision on the basis of application or interpretation, and we are inviting you to use your application jurisdiction. But finally, and this is again in the alternative, in the extreme that you still find that it's applicable and the plain meaning should be a conjunctive test, I would submit, because this is so intertwined to the determination of this petition, that you should find that section unconstitutional. I know the respondents say there are cases pending in the High Court on this issue, but it would be unjust for the court to use an unconstitutional provision which is so central in the determination of the matter without pronouncing itself. So, as I close, and if I may, take 1 minute, in our petition, you'll find that one of the issues that come out in terms of illegalities is whether the withdrawal of Honorable Raila Odinga and Honorable Kalonzo Musyoka, what the effect of that was on October 10th. And we are submitting that if you read Raila 2013, paragraph 290 to be precise, you will see what the court said about the effect of withdrawal. And it means that if a candidate withdraws, then, and they are the only other remaining candidate, you have to have a new election. At the time of withdrawal on October 10th, there were actually only 2 candidates because the decision of Justice Mativo was given on the 11th. And while the respondents argue that he should have filled out Form 24A, we submit that that form only relates to the issue of nomination. And the irony of all this is that if a form is not required to be filled for nomination purposes, why should it be required in the context of fresh election? Why should it be required in the context of withdrawal where it's not expressly provided? I just want to end by just sort of bringing the elephant to the room. And the elephant that is out there by Kenyans or with Kenyans. And the question is, can the court really nullify the election a second time? That's whether we like it or not, that's what Kenyans are asking. And they are saying, or some of them are saying, that because we've been put through this rigorous, circuitous, and very sort of stressful cycle, can the court really nullify? And my submission is that it can and it should, because this court does not work from public opinion, it works from the law. And when you look at what the Constitution requires, we are saying that the Constitution requires that this election be nullified. They're asking, and this will be my last point, who can afford another election? But the question then I would want to pose to the court is this the election you anticipated when you nullified the August 8th election? Did you anticipate an election with a 38.8% turnout? Did you anticipate an election where the presidential candidate in today's Kenya wins with 98.8%?
Mr. Waikwa, when this court issues orders, it doesn't anticipate such things as you are putting to us. We were not political actors. We acted as the Supreme Court of Kenya and issued an order that elections be held within 60 days. So for you to pose questions of percentages of turnout to us is absolutely unhelpful.
May I rephrase and say, is this the election then the Constitution anticipates under Article 38 and under Article 81E? Can we afford another election? And my submission is that this is not the election the Constitution anticipates, and yes, we can and must afford another election, because if we don't, then it renders the provisions relating to free and fair election in the Constitution meaningless. Unless there is any question from the bench.
Waikwa,
Yes.
is your concern in that regard just the percentage of those voting? Is that the main concern that you are addressing your mind to? I'm asking that because if you have done some reading outside the field of law and gone into the politics of elections, you'll find that if you hold a series of elections, one after the other, the voters get less and less and less. It is called voter fatigue. And there's nothing you can do about it, whether in America, whether in England, wherever. That one has been proved. So you need to address that.
Yes, Honorable Judge, I do accept your point of fact that numbers will tend to dwindle as you go down or as you do more rounds of election. In fact, maybe that can be attested through by election. But that's the first response would be, but can we expect a dip of 50% just within less than 2 months? Can we, scientifically? And the follow-up question is, why the dwindling percentage? And that is what my colleague answered when she was talking about violence, intimidation, and it's what I was trying to answer by showing that the turnout was not only affected by violence. And maybe just to pause here and ask, if this had been a parliamentary election where maybe 4 of 10 wards in a constituency did not vote, would the court say it was a free, fair election? If it was an MCA election, would the court say it was a free and fair election? I'm just posing, wondering about that, because these and other factors really do affect why the turnout was so low and lend us the aspect of universal suffrage not to have been met.
What you say?
Sorry, Madam Deputy Chief Justice.
What you've just said and the reasons for not voting. And you've taken a while, and your lead counsel has also taken a while to say why people who didn't vote. So the two must be read together, right?
The why and
whether one would call that a credible election,
yes,
and why certain people didn't vote would have to go together, right?
Yes, and my response to that, Madam Deputy Chief Justice, is to say, in fact, the why is what makes the election not credible. So when you look at the two, when you ask, why didn't the people vote, then you're pointed to the evidence why. And that evidence have to be assessed on a balance of probability, and I would submit that the test has been met. May I, Honorable Chief Justice, on behalf of my colleague who is coming up, just request an additional 10 minutes, also because of the question coming from the bench. Yes. May I just make that request?
Very well.
Thank you.